Hi everybody, I'm Bill Rogers. I'm an associate family lawyer at Russell Alexander Collaborative Family Lawyers. We help families with separation and divorce, and we upload videos about current family law cases and other interesting aspects related to family law. Without further ado, let's get into today's topic. Could vaccination status affect parenting time in Ontario? With the imminent rollout of vaccine passports in Ontario, there could be a new family law twist to the question of whether being vaccinated against COVID-19 is something that Canadian law or public policy can mandate for its citizenry. It's the issue of whether courts have or should have the authority to deprive an unvaccinated parent of the right to have parenting time with his or her child. And as reported by Fox News and other media sources, a U.S. court initially ruled that a mom who refused to get the COVID-19 vaccination should temporarily lose custody of her 11-year-old son. However, the same court later reversed the decision, reportedly in response to public outcry. The Chicago area mother, Rebecca Furlet, has been divorced for 7 years and shares custody and parenting time with the boy's father. She has chosen to remain unvaccinated due to prior adverse reactions to vaccines. And in a ruling made on August 11th and delivered via Zoom call, the court took the unusual step of ordering the mother to be vaccinated, or else she would temporarily lose custody of the child and be deprived of the right to see him in person. And the court said the order was to continue until the mother receives her shots. However, the same court later reversed the decision by vacating portions of that early August ruling, which paved the way for the mother to see her son again. This alleviated the need for her to bring an appeal, which she had vowed to do. If you're enjoying this video and finding it helpful, please give it a thumbs up and leave your thoughts in the comments below. The original decision had attracted media criticism because the court had arguably exceeded its own jurisdiction by taking the initiative to both ask the mother whether she was vaccinated and to make the order. In other words, her unvaccinated status was never raised or objected to by the father at any point in their custody proceedings. At the time of writing, this issue has not come up in Ontario family courts, and the outcome of a future case of this nature is still unclear. The only certainty is that under Canadian law, the overriding principle governing courts' analysis and decision-making in such a scenario is the best interests of the child. And in this context, the parameters of that test are still uncharted. However, it's possible that, for example, a child with a proven pre-existing medical condition might be judged to be at risk if exposed to unvaccinated parents or extended family members. And in such cases, a court could conceivably entertain a change in parenting time based on the need to ameliorate that risk. For separated and divorced parents in Ontario who remain unvaccinated, time will tell how it all plays out. To learn more about this case, you can read the full article linked to the description below. If you liked this video and found it helpful, please give it a thumbs up and let us know. You can also leave your thoughts on this case in the comments below. Please subscribe to our channel and hit the bell icon to get a notification every time we upload a new video. Thank you for watching.